these hearings by way of a virtual courtroom on video. You have the right to counsel, and Ms. Massara has been appointed to represent you. You have the right to discovery. Available evidence and information has been shared with you and your attorney. You have the right to testify at this hearing, call your own witnesses, cross-examine any witnesses who may appear, and to offer your own information by proffer or otherwise. Should you testify at this hearing, your testimony may not be used against you except in the following circumstances. If you testify untruthfully, then your testimony could be used in a prosecution for perjury or false swearing. If you testify differently at another hearing, as you might testify here today, your testimony later could be used to impeach you. And if you fail to appear and violate a condition or commit a new offense, should I release you, then your testimony could be used at the next hearing. Do you understand your rights, Ms.
Yes, sir.
Very well.
Yes, sir.
Great, thank you. It would appear that the state has demonstrated that there's reason to believe the defendant's an eligible defendant who committed the offenses charged on or about March 16, 2020 in Atlantic City at the bus terminal, consisting of disorderly conduct as well as resisting arrest, possession of disorderly CDS-related matters, as well as an attempt to disarm a law enforcement officer, crimes of the second, third, fourth disorderly and petty disorderly level. Having found probable cause, may I hear the state on detention?
Yes, thank you, Judge. Judge, the public safety assessment, as was already put on the record, is a no release recommended, 6 for failure to appear, 5 for new criminal activity. As you look on her public safety assessment, she is currently on pretrial monitoring, level 3 out of Camden County. And in looking at her pending charges, though they are all disorderly persons, over the course of 1 year, she has racked up 9 different cases. Looking at her failure to appears older or within the past 2 years, rather, she has had 20 failure to appears within the past 2 years and 14 failure to appears older than 2 years. So it's for those reasons, Judge, her inability to appear in court and her racking up new charges that we are asking that this defendant remain detained.
Thank you. And may I hear from Ms. Massara on release?
Thank you. Your Honor, in this particular instance, I would argue that the state has not met its burden with regard to any of the prongs of the triad. Namely, the public danger here, I think, is slim to none. Ms. Speier strenuously denies having attempted to take that officer's firearm. She does indicate that because of the way that the officers kind of grabbed her, the way that they had her pinned, and the way that they had her arm pinned, that any resting of her hand near the service weapon was accidental, unintentional on her part, and was simply a factor of the circumstances. And obviously at this juncture, we don't have body camera. We don't have video to kind of show us a better idea of that struggle. But Ms. Speier strenuously denies having ever attempted to go near the officer's gun, take the officer's gun. And while I didn't argue probable cause on that because the standard is so low, I do think that that charge ultimately will be shown to be a weak allegation. Essentially, looking at Ms. Speier's history, this is somebody who is clearly, suffering from substance abuse issues, not somebody who has shown any indication toward violent conduct or dangerous conduct. She is a panhandler. By all accounts, she frequents the bus terminal. It does not appear that she menaces anybody at the bus terminal or threatens anybody at the bus terminal. She's not a violent panhandler. She is simply somebody who does panhandle as a result of substance issues. So with regard to danger to the community, I think that we can say that, I feel that her danger would be slim to none. While I do understand that she does have a pretty extensive failure to appear history and that the court would have concerns about that, I do think that, most of those matters are municipal court matters. And with regard to that, again, nonviolent drug offenses. And I think she's very, very shaken up by being taken into custody in the way that she was. She knows the importance of appearing and meeting her court obligations. And this has definitely been a wake-up call to her. She's very frightened. She's very concerned for her health and safety given this pandemic. And with regard to, obstruction, again, she denies trying to take the officer's gun. She does admit that, she was scared of being taken into custody on this occasion. But, beyond that, she's aware that, she has to meet her court obligations in the future and going forward. She has community ties, mom and dad living in Galloway. She also does have a boyfriend in Atlantic City. He lives in his own apartment and he does have cerebral palsy. So she's been very, very concerned about him because he is alone. Obviously, we are in a pandemic situation. And I think, she has fear that he's not going to be properly cared for because of his disability and the fact that there's nobody else there with him. So for those reasons, Judge, I think while there are concerns about failure to appear, there are legitimate concerns, certainly with regard to her willingness to appear in court. She is very, very traumatized by this incident. She is very, very shaken. And with regard to the current health epidemic as it now stands, I do not think that this is someone who should be held in custody at this time. And for those reasons, I would ask Your Honor to release her with conditions.
Ms. Massara, are you aware of any mental health concerns?
Judge, I'm not aware of any mental health concerns besides, I think, some depression issues. She did suffer a loss of a close family member, and I think that has contributed to her use of substances. But other than that, I think it is purely substance abuse.
You mentioned the parents in Galloway. I take that's the 310 Great Creek Road address?
I believe so, Your Honor. And I believe Ms. Spire is nodding.
All right, we can put Ms. Spire's microphone on. And Ms. Spires, your microphone's on now, but I'm just going to ask you to respond when I ask you something, because we're trying to keep the record clear. Is your address? Is your address 310 Great Creek Road in Galloway?
That is my parents' address. There's also the address I can give you for my boyfriend, the one in the wheelchair.
Go ahead.
101 Boardwalk, Atlantic City, New Jersey.
Do you have a reliable phone number? 215-970-3349. That's, you're asking about his number, right? Either wherever you can be reached. And then
where I can be reached, let me give you a different number then.
Go ahead.
I thought you just wanted his opinion on it.
That's okay. Go ahead.
609-674-6304. And my parent, if you can't reach me there, you can always reach my parents at 748-1342. 609, of course. And they'll pass along a message to me. All mail, please send to 310.
And the 101 Boardwalk address, is there a unit or apartment number?
Yes, 224.
Does your boyfriend receive public assistance or disability?
I think he does get disability, but that barely covers his rent. And I have to go out and panhandle for food and, unfortunately, my previous heroin addiction. I'm clean now, though. 3 days in here, no more withdrawal.
All right. Well, look, Ms. Spire, the concern I have here is the allegation of the attempt to disarm law enforcement. And that's a serious charge that will have to be dealt with. I'm also aware that your record heretofore has not been overly serious. It's what we would call quality of life offenses and scofflaw behavior, which is not laudable, and you certainly have to avoid doing that in future. However, given the current health crisis, panhandling and attempting to hang out in public places, one, is going to get you in more trouble, and two, could endanger your health or the health of others.
Well, now I'm clean. I'm going to actually be going to Jewish Family Services and the VOA to look for a job.
Okay.
And get my birth certificate and an ID.
All right, I'm going to release you, and I'm going to impose conditions, and you're going to be reviewed with those conditions shortly with pretrial services. But I'm giving you the opportunity, one, because of the health concerns, and two, because of your family concerns, but you need to avoid contact with public places, and that includes the bus terminal. And certainly, if you're confronted by police, whatever the reason, you're never in the right position if you don't submit. Submit and fight about it later in court. You understand?
Yes, sir. Can I say one thing before we end?
Go ahead.
Um, I did try to, I will admit, he told me he'll give me
All right.
one chance to give him my
I'm
real
sure
name.
I'm sure Ms. Massara doesn't want you talking about the offenses, and you don't have to. I understand.
I know I don't have to, but I want to from my own point of view.
Okay.
And there was dozens of witnesses that I know. I gave them my real name the first time. I stood there where he said he wasn't gonna run me for any municipal. But I have stuff up in Camden. He started to take out the gloves. I knew what that meant. I turned, tried to run. He grabbed me, slammed me against the wall. But his right side was pinned on my right side. Again, my face was, look, I don't know if you could see, Judge.
All right.
Right
I
here?
understand. Thank you, Ms. Spire.
I was against the.
Listen. I understand the circumstances. Please listen to what I'm saying. And the first rule of holes is when you're in one, stop digging. Okay? All right, I've carefully considered the submissions of the parties, and I conclude that the defendant has a history of substance abuse, which may have exacerbated the conditions here. She's a low-level scofflaw. She has a disabled paramour, and given the current condition of this defendant, it would be appropriate to release her at this point, subject to rigorous conditions. The court does not find that there's clear and convincing evidence to show that no amount of monetary bail, non-monetary conditions, or a combination thereof would assure the defendant's appearance when required, the protection of safety of others, and she will not obstruct the criminal justice process. Therefore, she's released subject to the following conditions. Appear for all court proceedings, notify pre-trial services of any change of address, commit no new offenses, avoid all contact with the alleged victims, New Jersey Transit Police, avoid all contact with the New Jersey Transit bus station and other places of public transportation. Abide by the following specific restrictions on personal associations: no public begging or panhandling, reside at either of 101 Boardwalk, Unit 224 in Atlantic City, or at 310 Great Creek Road, Galloway. Mailing address in Galloway. Report to pretrial services telephonically once every other week and in person once every other week, except all contact by telephone until further order of the court. Comply with the following curfew, consistent with the curfew imposed statewide, which is in your residence from 8 p.m. to 5 a.m. Possess no weapons, refrain from use of any alcohol or CDS. Make contact with Jewish Family Services for available treatment and services. Court's made this determination on other relevant evidence presented to the court and defendant's chronic drug use. We have a pick date scheduled?
Yes, Your Honor, on April 29th before Judge Rao.
All right, this release condition is subject to any detainers. So if there are any municipal matters, they need to be addressed by the defendant before she can be released, subject to the municipal rules that are in place now. All right, you're going to be released later today, assuming nothing else is holding you, Ms. Spires. You need to be back in the courthouse in Atlantic County here in Mays Landing on April 29th at 9 o'clock, unless somebody tells you differently. And if you are detained anywhere else, you got to let us know about that immediately in writing. And if you're detained outside the state of New Jersey, your release on these conditions is a waiver of extradition. You'll be released, you'll be returned to face these charges. And if you commit a new offense, if you violate a condition or you fail to appear, a warrant will issue for your arrest. You could be detained. You could have other conditions placed on you. Have you understood all of that, Ms. Spire?
Yes, sir, I have.
All right. Good luck to you, Ms. Spire. Stay out of trouble.
Okay, sir, I have one
Yep.
more thing.
Yeah.
I've only been staying there with him for about a year. I was sleeping under the boardwalk before that. I always get his address confused. It's 225.
225 Boardwalk?
Yes.
225 is the unit. It's 101 Boardwalk.
Yes, sir.
Okay. I've got it. All right. and-
One more thing,
Sure. Go ahead.
I do have to go to the bus terminal because Jim, the one that hurt his ankle, I'm actually very, very, very friendly with him. He held all my things there. So I do have to go to the bus terminal to pick up my stuff.
No, you don't. What you need to do is contact the bus terminal by way of telephone and make an
Well,
arrangement.
this is what they told me to do.
Make an arrangement by calling them first. They have a dispatch number, and then make an arrangement for somebody, get the person's name, Officer so-and-so or Miss X, to meet you there, but do not
I
go
don't know
there.
his last name.
All right, just call them first is what I'm telling you. I don't want you showing up there and getting in the crosshairs of this again. Call them first. They have a dispatch number. Call dispatch from New Jersey Transit.
Could I send my boyfriend or my parents to go get it?
Yes, you can. You can't be there. They can be there so long as they don't breach the peace, okay?
If they have the same last name as me, right?
That's fine. Give them something in writing and they can go pick it up. Be well, Ms. Spire.
I'm sorry, Judge, my
All
bad.
right. Not at all. Thank you.
Thank you so much.
You're welcome.
All right, come here.
Okay, this matter is concluded, State versus Spire.
Thank you, Judge.
Thank you, Your
Thank
Honor.
All right, we'll wait for the jail to bring our next person in. All right, and may I have the name of the gentleman sitting in the jail? Just wait for your microphone, sir. Give us a moment.
Judge, he's not muted on our end. It must be something on the jail's end.
Okay, we'll ask the jail to double check. Okay. May I have the name of the gentleman in the jail?
Derek Tennell.
Thank you, Mr. Tennell. Give us a moment, please. I'm going to get your paperwork out now.
All right, sir.
All right, this is the state of New Jersey versus Derek Tennell on complaint warrant 0121-W2020-000092 for first appearance and prosecutor's motion for pretrial detention. Counsel may have appearances, please.
Assistant Prosecutor Gina Dianuntis on behalf of the state.
Mary Lenahan from the Office of the Public Defender on behalf of Mr. Tennell.
Thank you. And I see Mr. Tennell is present by way of video from the Atlantic County Justice Facility. Mr. Tennell, because of the current health crisis, we're conducting these hearings by way of video link, and we'll conduct it just like we would anywhere else. I'm going to ask everybody just to speak clearly and slowly. And please just respond when questioned so we can all hear each other and record it properly, okay?
Sir.
All right, thank you. Counsel, I have the following documents. I have the complaint warrant, which I've marked as S1. I've got a public safety assessment I'll mark as S2. That's dated March 16, 2020 at 9:18 a.m. with a recommendation of no release, citing a new violent criminal activity flag and a current violent charge, and a score of 4 and 5. And I have the prosecutor's motion, which is S3. Are there any other documents from the state?
No, Your Honor.
Are there any documents from the defense?
No, Your Honor.
And is the defendant aware of his rights at first appearance?
I conferenced with him on Monday
Yes, you did.
regarding first appearance. He would waive reading. He understands the nature of the charges against him, and he understands his rights.
Very well, thank you. First appearance
At the
then has
defense.
occurred. Thank you. First appearance has occurred, and there is no contest on probable cause, Ms. Linehan?
No, not on probable cause.
Thank you. Could I have a brief proffer for the record?
Yes, Your Honor. On March 14th, 2020, members of the Summers Point Police Department responded to the Wawa on Ocean Heights Avenue. While they were there, they met with the victim, who is a domestic violence victim in this case, and she stated that earlier in that evening, her boyfriend, Derek Tennell, assaulted her. They were inside of his vehicle, she indicated, and he was driving the vehicle. And while they were driving, they began arguing, and the fight then became physical. The defendant scratched the victim in her forehead, chest, upper lip, and bit her right pinky finger. And while the vehicle was stopped at a light, she then exited the vehicle and she walked to the Wawa. Officers also indicated that they observed visible signs of injury to the victim, specifically cuts on her face and blood on her forehead, redness to her pinky finger.
And Ms. Linehan, you were good enough to indicate your client's aware of his rights at the detention hearing.
We did discuss that on the phone. He's aware of his right to testify and to call witnesses. We're not going to proceed in that manner.
Thank you. Court finds probable cause to believe defendant's an eligible defendant who committed the offenses charged, that namely on or about March 14, 2020 in Summers Point, that he committed simple assault against the person of Sandra Washington in the course of a domestic dispute. Having found a probable cause, may I hear the state on detention?
Yes, Your Honor. The state submits that the PSA properly recommends no release, as this defendant is a danger to the victim and community, and he presents a risk of failing to appear and obstruction of the process. The defendant is 58 years old. He has one pending charge at this time, and he additionally has 18 indictable convictions. The defendant is currently charged with simple assault after biting and scratching the domestic violence victim in this case. Defendant, as shown by his 18 indictable convictions, has an extensive criminal history, which includes but is not limited to convictions for robbery, possession of a prohibited device, and other weapons offenses. Additionally, he has 3 indictable convictions for second-degree offenses. Furthermore, there was a restraining order previously entered against this defendant, and the basis of which was for an assault. The foregoing evidence demonstrates the defendant's dangerousness. Additionally, the defendant also presents a risk of obstructing the process, as evidenced by his conviction for second-degree eluding and obstruction and 5 violations of parole. The defendant also has 4 failures to appear. They were older than 2 years. However, there are 4 of them. And the defendant is also a flight risk, which is shown by the failures to appear and his eluding and obstruction. And for all those reasons, Your Honor, we submit that the defendant should remain detained at this time.
Ms. Diodontis, has your office had any contact with the alleged victim in the case?
I don't believe so, Your Honor.
Thank you very much. May I hear from Ms. Linehan on issues regarding release?
Thank you, Your Honor. My client is 58 years old. He's an honorably discharged veteran of the Army. He was Army National Guard judge for a period of 3 years, but he had enough active duty time to qualify for full services. I did reach out and have Mr. Walters verify that yesterday. So he's eligible for all VA services, and he's already linked up with the VA locally. We can have him access services there. He has a permanent address on Martin Luther King Boulevard. It's apartment 1041. He has a phone number. He's currently employed at the Hard Rock Cafe. This relationship has been ongoing for some years with Miss Washington. They do have separate residence. There's no need for him to have any further contact with Miss Washington. So Judge, additionally, his age puts him right in the danger zone for the current health issues that we're dealing with. And literature shows that jails are perfect transmission grounds for this contagious disease. Without corrections officers, care providers are in and out without. As a permanent residence, he's got full-time employment. He's eligible for services with the VA. I'd ask you to consider those things. Regarding the other issues that Ms. Dina just brought up, his failures to appear, there's one back into the 90s, 94 and 1990, and the earlier restraining order that Ms. Dina just referred to was issued in 1994 and subsequently dismissed. The open charge to which the state alludes is from 1985. It looks like it's out of Middlesex County. I don't know the status of that, but it's a 1985 charge. I don't know why it hasn't been addressed. Perhaps it's just an error there. Judge, I would argue that the state's failed to show by clear and convincing evidence that there are not non-monetary means that can guarantee this gentleman's appearance at court, his willingness to follow court orders and stay away from Miss Washington in this matter. I don't think he presents a danger to the community. He's been compliant since release from his last term of incarceration, has gainful employment, and a stable residence. He would comply with any orders of the court. Thank you.
Is anyone aware of the existence of any domestic restraints entered in this case?
No, Your Honor.
Carefully considered the submissions of the parties and the arguments of counsel. And while this matter is a domestic one where there is a recommendation of no release, the other compelling circumstances here that weigh against detention are the nature of the offense, which is disorderly, the fact the defendant has a stable residence not with the alleged victim, that he has current employment which may be available to him after the current health crisis passes, that he is a retired and discharged veteran who is eligible for services. For all those reasons, the court finds there is not clear and convincing evidence to support that no monetary bail, non-monetary conditions, or a combination thereof would reasonably assure the defendant's appearance will require the protection of the safety of others, including the victim, and the defendant will not obstruct the criminal justice process. Therefore, defendant is ordered released subject to the following conditions. Appear for all court proceedings, notify pretrial services of any change of address, commit no new offenses, avoid all contact with the victim identified with the initials SW. Reside at 1041 North
Dr. Martin Luther King.
MLK Boulevard, apartment
Yes, sir.
1041 AC, New Jersey. And could I have a phone number for you, sir?
Home phone number 609-344-5577. My cell number 609-334-3253.
Okay. Report to pretrial
Aye.
services. Let me finish up, sir. Telephonically once every other week and in person once every other week until charges are resolved. And telephonically only until further order of the court. Possess no weapons. Abide by the curfew imposed by the state, which is 8 p.m. to 5 a.m. Refrain from the use of any alcohol or any CDS. Make contact and engage with VA services to include a course of anger management. Commit no acts of domestic violence. Obey all orders of restraint. Court's made this determination based on other relevant evidence presented to the court, namely the VA engagement, as well as the defendant's current or prior domestic charges. And the matter appears to have been scheduled in the municipal part in Summers Point on Tuesday, March 31st at 5 p.m. Given the fluidity of the situation, that may change. So Mr. Tennell should contact the Summers Point Municipal Court when he is released telephonically and find out if his date has changed. He can certainly wait till next week to make that call. The court may not be available owing to the previous order of the Supreme Court shutting down municipal courts for 2 weeks. Now, sir, you'll be released on these charges. You're answerable to the Superior Court for your conditions. You're answerable to the municipal court on the charges. If you're detained anywhere else, you got to let us know about that in writing. If you're detained outside of the state of New Jersey, your release on conditions constitutes a waiver of extradition. You'll be returned to face these charges. And if you fail to appear, you violate a condition or you commit a new offense, a warrant will issue for your arrest. You could be detained. You could have more conditions placed on you. You understand all your conditions, sir?
Yes, sir.
All right, sir. You'll
Your
be
Honor.
released. Yes, sir.
I have one concern. Miss Washington has spoke with my mother and my sister,
I
and
would advise my
she-
client against proceeding any further with the comments. The municipal court date is scheduled in short order. And if there's anything further that needs to happen, that can be addressed in municipal court. I would like to ask, Your Honor, if I can get my client's permission to give his cell phone number, 609-334-3253, to Mr. Walter of the VA, so he can make contact with him in that manner. I don't have Mr. Walter's number handy right now.
Is that okay with you,
Yes.
Mr. Tennell? All right. Mr.
Yes,
Tennell,
sir.
please sort it out with the municipal court. If the charges are dismissed, well, then, you'll be okay.
They are.
All right, well, they're not
They are.
yet.
She
They're not yet.
told the prosecutor 3 times. All right, sir.
All right,
All right,
I
sir.
get you. You're gonna be in Summers Point. If it's dismissed, it's dismissed. And then these conditions are dismissed. But take advantage of
All
the
right.
DA. It gives you an opportunity to get yourself on a good path, all right? Thank you.
Yes.
This matter is concluded.
Thank you.
Thank you, public defender. Y'all have a good day.
Okay.
Thank you, Your Honor. I don't have any further matters.
Thanks, Ms. Linehan. Be well.
Thank you.
Thank you, Mr. Nunes. Be well.
Guys won't pick anything fuck up. They're pulling 40 to do a shower detail apparently, so. Okay, let's fucking only 4 and 11.
And your background, too, so that works out well. Go to the last one. Just have a seat right there.
All right, is this Mr. Jamel Williams?
What's that? Yes, it is, sir. Good morning, sir.
Good morning, sir. We're going to be conducting this matter by way of video link to ensure that everybody is recorded properly and heard fully. Just please wait to interact. I'll direct when it's time to respond and when it's appropriate for you to make a comment so we can make sure that everything's recorded properly. You understand that, sir?
No problem.
All right.
Yes,
thank you.
sir.
All right. This is the state, we'll begin this proceeding now. This is the state of New Jersey versus Jamel S. Williams on complaint warrant 0112W2020 000347 for first appearance and prosecutor's motion for pretrial detention. Counsel, may I have appearances, please?
DeAsia Laws on behalf of the state.
Heather Ann Sennigan for the Office of the Public Defender on behalf of Mr. Williams.
Thank you. Counsel, I have the following documents. The complaint warrant, which I've marked as S1. I have a public safety assessment I've marked as S2. That's dated March 16th, 2020 at 9:17 a.m. with a recommendation of no release based on a Graves charge and a score of 4 and 4. I have the prosecutor's motion, which I've marked as S3. I've also received from Ms. Sennigan 2 photographs, which I have reproduced here for the record, which I'll mark as D1 and D2. They appear to be pictures of a suede rifle sheath that is displayed on the trunk of a car, and I'll of course await further discussion of those. Are there any other documents from the state?
No, Your Honor.
Any other further documents from the defense?
No, Your Honor.
Is your client aware of his rights at first appearance?
Yes, Your Honor. I was able to discuss telephonically with him yesterday his rights. He understands those rights. I also explained his charges. So we would waive a reading and mark the first appearance as complete.
Very well, first appearance has occurred. Will there be a contest on probable cause?
For the purposes of this hearing, no, Your Honor.
Very well. Ms. Laws, may I have a brief description of events for the record?
Yes, Your Honor. Based on the affidavit of probable cause from the trooper in the township, central search warrant at 5096 Road, Newtonville, Atlantic County. After conducting 2 controlled purchases of CDS in previous weeks, during the search of the residence, 2 22 rifles and a 16-gauge shotgun were recovered, as well as CDS, including heroin, crack cocaine, methamphetamine, ecstasy, oxycodone pills, and marijuana under 50 grams. And also 2 30-round Glock extended magazines were also recovered. In regards to this defendant being a certain persons, I ask that the court take judicial notice of the PSA, which the defendant has multiple prior convictions for possession with intent to distribute charges that would make him a certain persons in the 2nd degree. And for probable cause, the state will submit.
Ms. Sennigan, is your client aware of his rights at the detention hearing?
Yes, Your Honor.
Court finds reason to believe the state has shown defendants an eligible defendant who committed the offenses charged, that namely on or about March 14, 2020 in Hamilton Township, that he was in violation of law by having in his possession controlled dangerous substances, crimes of the third degree, and had them in his possession with intent to distribute, crimes of the third degree, and that he had in his possession firearms as a convicted person and as contrary to law in possession, and those offenses being in the second degree. Having found probable cause, may I hear the state on detention?
Yes, Your Honor. The PSA recommends no release. The defendant is a 4 for failure to appear or 4 for new criminal activity. There is no new violent criminal activity flag. The PSA properly recommends no release as the defendant is a danger to the community, presents a serious risk of obstructing the process or failing to appear in court. He's currently on probation and has been charged with possession of a firearm while committing a CDS offense, being a certain person not to possess a firearm, possession of large capacity magazines, multiple counts of possession with intent to distribute, and other CDS related offenses. The foregoing evidences the defendant's dangerousness to the community. Furthermore, the defendant has an extensive criminal history, which includes 7 indictable convictions. The fact the defendant has not remained law-abiding while on probation in conjunction with his prior convictions for contempt evidence his risk of obstructing the process. His violation of parole provides additional evidence of his risk of obstructing. The defendant is also a flight risk as evidenced by his recent failures to appear. His risk of
Ms. Laws, your connection may be buffering.
Hello?
Hello, can you hear me now?
I'm sorry.
That's
I
all
can hear
right.
you now.
We lost you right after his failures to appear.
Oh, okay. I'm sorry. I think
Right.
it kicked me out of the system. Okay, so his risk of flight is heightened by his out-of-state ties to New York and potential for a lengthy term of incarceration upon conviction. And I believe that was it, Your
Thank
Honor.
you.
So for
Thank you,
those
State.
reasons, the state was submitted. Thank you.
Okay. May I hear from Ms. Hennigan regarding release?
Yes, Your Honor. So first, we would like to address the most serious charge, which of course is the allegation of possession of weapons. My client maintains that he did not even know those weapons were on the property. My investigator also went out and spoke with his wife. According to her, this property is a family property. It's been in the family since the 60s. Numerous generations of the family has lived there. It used to work as a family farm. And these guns belong to someone else in the family. His wife had completely forgotten they were even there. They were found down in a corner of the basement. The pictures that I submitted were pictures that my investigator took of the case that they were found in. As you can see, it's old, it's falling apart, it's moldy. It's been down there obviously for quite some time. As I stated, his wife had completely forgotten they were even there. My client had no idea they were there at all, as they belonged to some other family member. When they moved into the house, the grandparents still lived there. So it's suspected they either belonged to them or possibly even a prior generation of his family. So it's our position that this charge relating to the guns will be resolved in favor of my client, as his wife has claimed possession of those weapons on behalf of her family, and the fact that they were there even before my client had even moved into the property. And again, he denies that he even knew they were there. He told the same thing to the officers when they were there asking him about the weapons. He kept saying, "What weapons? I don't know what you're talking about." So when you take away the guns charge, then all you have is the charges for the CDS, which are nonviolent. My client currently is enrolled in the drug court program. I believe that's the probation that the state was talking about. He's been in there for about a year. He's been doing very well in there. I had occasion to speak to Nellie Marquez, who was our drug court attorney. She said that there's been no issues with him, that he's been doing fine in drug court. So I think that displays that he is able to be on some sort of supervision and show up when he's supposed to show up to follow a program. So certainly that demonstrates that if released, he would be able to follow any orders that the court would put on him to show up when he's supposed to. As far as the failures to appear, there are two. There's one from, I believe, last year, and then the only other one is from 17 years ago. So certainly that's not massive failures to appear. He forgot one time in the last 17 years. He has deep ties to this community. He's lived here for the past 20 years. He currently is employed full-time with Tyson Chicken. He was actually in training for a promotion with that company. He's married, lives with his wife at the address where he was arrested. He has 3 children, a 20-year-old, a 17-year-old, and an 11-year-old who all still currently live with him, and he provides support for them. His wife does work, but she works part-time for a school, and with everything that's going on right now, she's obviously out of work. So right now he is the sole income that this family has to rely on, the steady income. He has, although he does have prior offenses, all of those indictables and all of the things from before are CDS offenses, which I think speaks to the fact of why he's in the recovery court program. So he doesn't have any history of violence. There's no history of other gun charges or anything to that nature. So we believe he's not a danger to the community. We also believe, given all of his strong ties, the fact that he's lived here for 20 years, he has a job here, his family's here, he's certainly not a flight risk. So for those reasons, we believe that he can be released upon conditions, and that we would ask therefore that the court release him.
Thank you, Ms. Hennigan. Ms. Laws, can you speak to, with obviously very likely the warrant and the affidavit have not been discovered yet, but can you speak to the circumstances of the investigation up to a certain point leading to the search warrant? Yes, if you could. I know the affidavit and search warrant have likely not been discovered yet, but if you can speak to certain aspects of the investigation that led to the execution of the warrant, that would be helpful.
Yes, Your Honor. Based on the reports that I was able to turn over to defense, there were 2 different controlled buys with different confidential informants that were able to purchase CDS, who stated they purchased from this defendant at that address, which led to the search warrant. And both of those, which was indicated in the reports that were turned over, that at least one of the confidential informants previously saw the defendant selling drugs out of that residence, along with having a firearm while present at that time of selling those CDS to them. So that was the basis for the search warrant.
Was the search warrant executed on a tactical or no-knock basis that you're aware of?
1 second, Your Honor. This was a part of a no-knock, Your Honor.
Thank you. Give me a few moments, counsel.
And it was signed by Your Honor.
So I can consider my
Okay.
decision. Thank you. I've carefully considered the submissions of the parties. I reviewed States Exhibits 1, 2, and 3 in Defense 1 and 2, and the proffers as submitted. And based on my review, the court finds clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination thereof would reasonably assure the defendant's appearance in court when required and the protection of the safety of others, and therefore pretrial detention of the defendant is hereby ordered. My reasons for this decision are as follows. The nature and circumstances of the offenses charged. These are drug and firearms offenses which increase public danger. Controlled buys in the presence of firearms and a no-knock warrant were executed. The court also has considered the weight of the evidence against the defendant, considering any admissibility concerns. Evidence includes personal observation of law enforcement and physical evidence, including recovered CDS and weapons following the execution of the warrant. The court has also considered the history and characteristics of this defendant, including his character and his family ties and employment. He has strong ties and employment. However, those ties are checkered with frequent adverse contact with the criminal justice system. The court has considered his criminal history as reflected in the PSA, which is extensive. The court has considered his record concerning failing to appear as reflected in the PSA. While not overly extensive, the increase of risk of failing to appear is present owing to the nature of these charges. The court has also considered at the time of the offense or arrest on these charges, the defendant was on probation in recovery court. A rigorous supervision in recovery court has proven inadequate to ensure public safety and accountability to the court by this defendant. The court has also considered the nature and seriousness of danger to others posed by the defendant's release, namely the presence of firearms increases the risk to public safety. The court has considered the release recommendation of pretrial services using the risk assessment instrument where release was not recommended. In this case, the PSA is particularly weighty evidence supporting detention. This defendant, while under supervision of recovery court, engaged in distribution activities on numerous occasions from his residence where firearms were present. The danger to the public and to probationary staff is palpable. The defendant's risk of flight is elevated owing to the virtual certainty of imprisonment with parole disqualification upon conviction. Detention is necessary to meet these two important prongs of the triad. However, the recovery court's review of his detention status is permitted as facts and circumstances may warrant. Defendant may consult with counsel if that is desired. He has 7 days to appeal. The matter will be listed in recovery court for review. Thank you.
Thank you, Your Honor.
Thank you, Your
There's
Honor.
nothing-
Let me
Thank
get-
you. This matter is concluded.
There's nothing,
Does he have a pick date?
Pick
I-
is
429 before Judge Taylor.
429
Your Honor, I
for Judge Taylor. Thank you.
Your Honor, I thought you said I'll be able to say something to you.
If
if
you want to say
anything. I thought
something,
you
go
said I'd
ahead,
be
sir. Wait. Say something if you want to, but I recommend that you don't. Everything you're saying is being taken down, but go ahead.
No, that's, I understand that, sir, but, the weapons charge, I honestly, and I really didn't know that those weapons was there. That's why my wife had made the statement that she made. I've been with my wife for 23 years now. We moved down here from New York to that house where her grandparents were still living and staying there. There's things inside of that house. Her grandparents still have clothes and things of that nature in their bedroom. They've been deceased for years. And down in the basement, we only use one half of it. So I had no acknowledgement of anything else that was down inside them basements or wherever they found it at. That's why she had wrote the statement, because I've never had guns on my jacket. I've never carried any guns. I've never played with no type of guns. I honestly knew nothing about it, and that's why she had made the statement that she made. To take the guns for her that's in her family's house. I'm not even on the lease in that house. I just stayed there with my wife and my kids. I honestly didn't know anything about those firearms.
All right, sir. That was brought to my attention by your counsel. Made my decision. You have 7 days to appeal. Thank you.
Thank you.
You're welcome.
Thank you, Your Honor. I guess I'll see you in a few minutes.
Yeah, I think I have one more matter, which is going to be at 11:30, but if everybody's ready for it, it's State versus Herbert Manuth, I believe.
Your Honor, who do you need from the state?
Yeah, it is Desposito and Yvonne Marr.
I will let him know.
Thank you.
You're welcome.
I'll stand by here, but
Okay.
if anybody wants to click in, just let me know.
That concludes my matters. Have a good day.
Thank you, Ms. Hennigan. Appreciate it.
Judge, do you want to say that you're off the record at this point?
Sure, we are off the record, although Court Smart is running in background. Everyone should be aware that we still are recording. We're off the record regarding detention hearings. Thank you.
Your Honor, he's going to sign on now.
Thank you.
You're welcome.
Hello, Mr. Desposito, can you hear me? Try it now. Okay, I'm still not getting audio from you. Can you hear me? Thumbs up, thumbs down? Thumbs up, okay.
Mr. Desposito is unmuted on our end, so it should be, he would have to unmute on his end.
Okay, on your end, if you click on your picture, Mr. Desposito, a blue button should show up on the top right saying mute or unmute. Want to give a volume check again, Mr. Desposito? Yep, not coming through on our end.
Hey, Chris, you want to come over to my office? Is it working, Judge?
Yeah, I can hear you, Mr. McKelvey. Thank you.
Chris, come on over.
Judge, we're trying to reach out to Miss Mayor too to get her to sign on as well.
Great, and just let the jail know too that if Mr. Manuth can be brought over from the pod, that'd be great.
Got it.
Would you just turn off one of the banks of lights because we're getting, it's reflection, so. Okay,
You're still waiting for a defense attorney for Chris's case?
yes, we are, thank you. It's Miss Marr, she should be on shortly.
Okay.
Turn that one off, the other one back on.
Wait, this one? The one in behind you is off.
Yeah. That seems to be a little better.
Is that better?
Yeah, can you see okay on your end?
I don't have anything.
All right, but
Yeah,
as far
so
to
but
do
how
your
do
work,
you
you got
do my
enough
work?
light?
Yes, Judge.
Okay.
Yes.
Hi, Judge.
All right, great. You're loud and clear. Thank you, Mr. Desposito.
No problem.
All right, I've seen, is this Mr. Manuth joining us?
Yes, sir.
All right, we're going to put your microphone on mute for a few moments. We're getting everybody together, then we're going to address your case, all right? Okay.
This is a test from the desk of Christopher Desposito.
Loud and clear from the desk of Christopher Esposito.
Thank you, Your Honor. Chris, get out of my chair, and I'll see you in a minute.
Thank you.
Judge, Miss Marr is signing on right now, so it should only be a couple more minutes.
Thank you, Melissa.
You're welcome.
Mhm.
Can you just let him know he needs
Tell them to phone in and
Phone
no
in?
reporting. All right, great, thanks.
Thank you.
Probation, do you know if probation's going to the jail as they usually do, or, you know, for, yeah, just, you know, I'm sure no one's writing any PSIs over there right now, but if anyone plans on going to the jail, it'd be nice to know. They don't have to, but just be nice if they don't. 1 2 1 2. One two 1 2 1 2 test. All right. I see we have Mr. Desposito and Ms. Marr on the line. Can both parties hear me?
Yes.
Okay, and I see that Mr. Manuth is at the Atlantic County Justice Facility. I see him on video. Mr. Manuth, can you hear me okay?
Yes, sir.
All right, I'm just going to mute your microphone for a few moments in the background so that we don't pick up any ambient noise. I'll turn it back on at the appropriate time so I can hear you, okay?
Yes, sir.
All right. We're on the record. Counsel, I advise you that Court Smart is running in the background constantly, so I'll indicate we're on the record for purposes of the proceeding, but it's always being recorded. This is the matter of State of New Jersey versus Herbert Manuth on Atlantic County Indictment 1908-1743 for defense motion for release and sentencing. Counsel, may I have appearances, please?
Hello, Your Honor. Assistant Prosecutor Chris Desposito appearing on behalf of the state.
Good morning, Judge. Yvonne Marr on behalf of Herbert Manuth.
Thank you, counsel. I know you've been in contact with each other by way of email and with the court, and that both sides are of the mind that either the court could reach the motion and return the defendant on a no-show, no-rec basis, or if agreeable, reach sentencing and then give the defendant a date to report to probation. Obviously, if you should fail to do so willfully, that would be a violation and might have the same outcome as a no-show, no-rec. So I'll leave it to you. I'm prepared to reach sentencing so we can touch the matter once and allow the defendant to report to probation from the street within the next 30 days.
Judge, it's my position that we can move forward with sentencing today.
All
I
right.
agree, Your Honor. Thank you.
Very good. All right. This matter is now on for sentencing. Motion to release is withdrawn as mooted, counsel?
Correct, Your Honor.
Very well. Motion's withdrawn. I'll hear you on sentencing, Ms. Marr.
Thank you, Your Honor. Your Honor, I did have an opportunity to review the pre-sentence report. It was provided to me yesterday by Mr. Weppy. I did not have an opportunity to go over it with Mr. Manuth, given the quick scheduling of this matter. But I do believe after all my other discussions with Mr. Manuth, it is correct. I have no additions or corrections. I am going to ask Your Honor to follow the plea agreement but with one minor adjustment, which has been noted in the PSI. We are asking for a 1-year period of probation. Again, that's not something that wasn't included in the the pre-sentence report. And I think that it's appropriate in this case for a couple of reasons, Judge. Number one, Mr. Manuth has spent a significant amount of time in jail on this offense. He's been incarcerated since early July of 2019. So he has spent a number of months in jail. One of the main concerns, I think, in this matter is the contact with the victim, who is actually his sister. She has an active final restraining order against him. So it would appear that that would be in place. And so probation would not, or extended probation would not be necessary to ensure that he not have contact with her. There appears to be no indication of alcohol or drug related problems with this particular incident. It was simply an occasion where Mr. Manuth went into the victim's garage and got some guns, actually pieces of guns that he had been told, or at least he felt had been told he could take. So I think given the circumstances in this case, it doesn't involve violence or drug or alcohol use, the main thrust of concern in this case has been alleviated by an active final restraining order. I think that in a 1-year period of probation would be adequate. Thank you.
Thank you very much, Ms. Marr. Mr. Desposito?
Thank you, Your Honor. We leave it in the court's discretion as to the duration of probation, although I do respectfully disagree with Ms. Marr that a year is sufficient. I just think this case showed a profound lack of judgment and shows that the defendant needs some type of supervision. You can see from the PSR that he had a serious first-degree prior conviction and he served prison time. What I would suggest is something more than a year, but if he performs exemplary, he can certainly come back to the court and ask for less. It is true that the victims feel strongly about this. They do have a restraining order. They would like also a no contact order, even though it overlaps. They've asked me to please ask for that as a condition. And Your Honor has a flavor of the case from the PSR, but essentially he took guns and was in the process of cleaning them to make them serviceable, and so he could further sell them. So that just goes to our concern, which is that It showed a profound lack of judgment. I mean, he's a certain person. We negotiated it out of the Graves Act because it was kind of a unique factual setting, but I still think this is someone who could benefit from supervision. Thank you.
Thank you. Mr. Manuth, you have the right to appeal your conviction and the sentence you're about to receive to the Appellate Division of the Superior Court. You have the right to counsel during that appeal. If you can't afford one will be appointed for you by the Office of the Public Defender. You'll have 45 days from today's date to appeal. If you fail to do so, you'd lose that right unless you had a good reason for your failure, and the court may give you 30 more days. After that, if you don't appeal, you would lose your right to appeal. You may bring a petition for post-conviction relief within 5 years to this court. Do you understand your rights, sir?
Yes, sir.
All right. Is there anything that you would like to say regarding sentence?
No, sir.
All right. The defendant's knowingly and intelligently accepted his appellate rights. I'll ask Ms. Marr to follow up to complete the appeal rights forms at the appropriate time.
I will, Your Honor.
Very well. Before the court for sentencing is Herbert Manuth, following a negotiated plea to an amended charge on unlawful possession of a firearm in the 3rd degree, calling for sentencing to a probationary term. The defendant was originally charged with more serious Graves Act offenses. The defendant is, again, 54. This conviction seems to stem from a disturbance amongst family members regarding ownership of property belonging to parents. Among such property was the firearms in question. The defendant reports no serious substance issues. He is currently unemployed but has worked gainfully in the past. He has completed his secondary education. His criminal history shows 7 arrests with 5 prior convictions, including 3 disorderly convictions, 1 conditional discharge, and 2 indictable convictions. His indictable convictions are related to CDS. He has been to state prison before. There is a final restraining order in place with respect to the incident. The defendant will need to comply with conditions of probation in order to remain law-abiding. Aggravating factors 3, 6, and 9 apply and preponderate over mitigating factor 10. The plea bargain is in the interests of justice. The court will impose the recommended sentence. On indictment 19-08-1743, amended count 3, unlawful possession of a long rifle, a crime of the 3rd degree, impose a probationary term of 2 years, PSF $5, Safe Street 75, BCCA 50, LETF 30, a DNA sample, 258 days county jail, all credit for time served. Any remaining counts, DPs, and warrants to be dismissed hereby are. The standard conditions of probation are applied. Defendant may possess no weapons. He commits no acts of domestic violence. He obeys all orders of restraint. He has no contact with any victim. He forfeits any property seized. And he shall remain law-abiding, arrest-free, and keep the peace. Mr. Manuth may be released today on these charges. Now, Mr. Manuth, you're going to need to report to probation. I'm going to give you until April 17th to report. If the health emergency is still in place, this can be done telephonically. So my recommendation to you is when you leave the jail, call the courthouse, ask for probation, adult supervision, tell them who you are and what has happened, and they'll arrange a reporting schedule for you. That hasn't happened between now and the next couple of days. You have until April 17th to report, physically report to the courthouse unless you're turned away, obviously, if the health emergency is continuing. If you have any questions, you should contact the courthouse. Court staff will still be on duty in the courthouse, even though you might not be physically able to appear. Have you understood all that, sir?
Yes, sir.
Very good. This matter is concluded. Thank you.
Thank you, Your Honor.
Yvonne, thank you.
You're welcome, Mr. Manuth. Good luck.
And
Yeah, you
counsel,
too.
counsel,
God bless.
Council, I believe that will probably resolve our list for today. And I see Ms. Wise is still on. Anything I can help you with, Ms. Wise? Ms. Wise, anything I can help you with?
Judge, no, I don't know if you can hear me, but I was just here in case she needed coverage on Xavier Mendez, which was postponed for Sarah Weinstock.
Thank you very much. I see
Thank you.
Mr. Malky Burgos is on. Anything I can help you with, sir?
Your Honor, I'll go walk over to Emmons' office. I think he might just be logged in.
I see him perhaps coming on. We're unmuting him on our end.
Judge, it doesn't look like he has the speaker capability. I only see that the camera is off.
That he's observing. Okay. If anybody should need anything, please reach out for Ms. McGee here at court, Atlantic County Court, and then we'll try to help you out. I believe this afternoon we have a session with Cape May County to go over excludable time matters. All right, court in Atlantic is adjourned for now. Thank you.
Thank you, Your Honor.
Mary, I see that you're in, but I don't have any audio for you, and the camera is showing as off.
Karen?
Mary, I can see you. Hold on. Talk again. I think I heard you too.
Can you hear me now? I think I have the audio updated.
Yes. Yeah. Everything's perfect now.
I'm sorry to be a nuisance. I had trouble with my office tablet and I just wanted a backup so I wouldn't, you know what I mean? Like not be
Absolutely.
able
I
to-
mean, you don't want to have it where, you can't hear during
No,
that.
it was good. I found the tablet hard to work with because it's so small. So thank you for letting me test this. And I have Outlook here. So I should just be able to click in now in the future, right?
Yes, absolutely.
All right. Thank you very much. I just want to try muting and doing the different things because I had. All right.
I had a call hearing next week. I gotta contact the attorneys.
I can't hear you now, so you are muted on my end.
And let me make the video go away.
Yep,
And now.
the video is gone.
Okay, so that was so much easier than what I was doing on the tablet because I had to do it. All right, thank you so much for letting me test, and I guess we're going to all have this figured out and be really good at it for a while.
I really hope so.
Thank you. Thanks, Karen. Bye.
Bye.